All right, so thank you all for having me here to present for you on the right to know law. Today's presentation is going to be a NHMA presentation on RSA 91A, otherwise known as the right to know law. We're going to go over meetings, record keeping, producing public records, a general overview of sort of all things RSA 91A. My name is Jonathan Cowal. I'm the Legal Services Counsel here at NHMA. As we go through this presentation, we are recording so that you all can have a copy of the recording once we're finished. And if anyone has questions, I think we've got a few people here in the room and then at least one person joining me on Zoom. So if anybody has questions during the course of this presentation, please feel free to interrupt me. For those of you in the room, I can see a few of you on screen, so it may be easier if somebody just kind of yells out for me to stop, and then I'll stop and take questions as we go. So anything that comes up, feel free to ask. So for anybody who doesn't know, NHMA provides access to our legal services department as one of the benefits to our members. You all are a member of NHMA, which means that Monday through Friday, 8:30 to 4:30, you have access to our legal services department. We can be reached via email at legalinquiries@nhmunicipal.org, or you can call us at 603-224-7447. One of the two attorneys available will be able to help answer general municipal legal questions. If we can't answer your question directly, we can usually direct you to the right resource to hopefully help get your question answered. And we try to provide a response within around 48 hours. And so feel free, anytime you have a legal issue come up to run it by us. We're always happy to answer any questions that might arise. We also have available for free on our website access to our publication, the Right to Know Guide. We do update this regularly. I think this picture is old. We have a 2025 edition out now. It's available to our members on our website. It covers everything that I'm going to talk about today in more detail, as well as additional topics on the right to know law, including some handy table of cases, statutes, and checklists. So be sure to pull a copy of this publication to have on your computer somewhere as a reference in case you need to look up anything right to know related. So the right to know law in general is broken up into two parts. The way that we look at it is that the first half of RSA 91A deals with public meetings. This has everything to do with notice and recording and open to the public and hosting meetings, hosting hearings, taking minutes, things like that, all things related to properly holding public meetings under the right to know law. That's the first half of RSA 91A, and it's what the first half of my presentation is going to cover. The second half of RSA 91A deals with municipal and governmental records, record keeping, producing public records, and retention of public records. That's the second half of RSA 91A, and we'll cover that in the second half of the presentation. So to start, how does the right to know law, RSA 91A, govern public meetings? Well, first and foremost, only public meetings and public hearings are covered by the requirements of RSA 91A, which means if something is not a meeting, otherwise referred to as a non-meeting, that means that the rules of RSA 91A may not apply or may not apply in full to something that doesn't constitute a meeting under the law. So understanding what is a meeting and what is not a meeting is the first step in knowing what the requirements are going to be for you to hold a proper meeting. And in order to hold a proper meeting, there are certain rules that you have to follow, certain actions that must be taken, and we're going to cover some of the intricacies and tips and tricks of holding virtual meetings or aspects of meetings that might be virtual. I'm going to try to close this window. I think it's getting some glare on the screen. Okay, that's better. All right, so in order for something to be considered a meeting, it's always going to have these four elements, and it needs to have all four of these elements in order for it to be a meeting. If any one of these elements are missing, it means that you don't have the proper requirements for a public meeting, which means that either you can't hold the meeting, or if you were to conduct business without all of four of these elements present, you may potentially be in violation of RSA 91A. So it's really important to understand what each of these four elements are and how they contribute to making something a legal meeting under the law. And so the four elements needed to have a meeting under RSA 91A is a quorum or majority of a public body convening so that they can communicate contemporaneously and discussing or acting upon official business. So each of those four elements are necessary for you to hold a proper public meeting, and each of them warrants a little bit more deeper understanding of what they are. So the first is quorum. This is probably the easiest of the elements to understand because in essence, it means a majority. So if you have a 3-member select board, you must have at least 2 out of those 3 members present in order to hold a meeting. If you have a 7-person planning board, you must have at least 4 out of those 7 members present in order to have a meeting. Public boards and bodies can't define a quorum as being more than a majority in order to circumvent the requirements of the law. And in rare instances, another statute might apply, which creates a larger number for the purposes of a quorum or decision-making. That doesn't happen very often, but one of the most common instances of this is with the ZBA. The ZBA, Zoning Board of Adjustment, is a 5-member public body, which means that a quorum is 3. So you have to have 3 ZBA members present in order for them to go forward with a public hearing. The catch is a majority of 3 is 2 out of 3. But for the ZBA, if you only have 3 members present, in order for the ZBA to actually approve a variance request or a special exception, they always need 3 yes votes. It says it right in the statute. So what that means is that even if you have a quorum of your 5-person ZBA, meaning 3 people, 3 out of the 5 present, you're still always going to need a minimum of 3 concurring votes in order for something to pass. So that might be an example of another statute changing the quorum requirements a little bit. But for the most part, you need a majority of the members of your board or body present in order to hold a meeting. And then votes and motions always pass by a majority of who's present, except for that example of the ZBA. So if you had 4 out of 7 members of the planning board present, a majority is going to be 3 out of those 4 voting. So that's where quorum can get a little bit tricky, but for the most part, it's easy enough to find as a majority of the public body. Now, what is a public body? There are certain public bodies that are straightforward, and we all know and understand that they are, in fact, public bodies. That would be your statutorily created government entities, your planning board, select board, zoning board, board of commissioners, heritage commission, budget committee, an official budget committee, library trustees. All of these entities that are created and listed in the statutes are obviously public bodies. And anytime those entities meet, they are held to the standards of RSA 91A. But sometimes municipalities can get confused as to what other types of public bodies or committees actually qualify as a public body under RSA 91A. And where we see this the most is when we get into advisory committees. Sometimes the select board, maybe the planning board, or some other public body will create a small advisory committee, a 3-person, the select board might create a 3-person road maintenance committee, a group of individuals who are tasked with monitoring the roads during the wet season, the mud season, and helping advise the select board of which roads may be in need of a weight limit restriction due to the conditions during the wet season here in New Hampshire. So maybe my select board created a 3-person, road advisory committee, and all they do is they engage in fact finding. They monitor the roads in town. If they meet, all they're doing is discussing whether or not the conditions of a particular road are bad enough that they should bring it to the select board's attention, but they don't really make any decisions. They don't take any votes. Maybe you call these meetings of the road committee fact-finding sessions or information gathering sessions. And sometimes municipalities think that these advisory committees during their fact-finding sessions or information gathering sessions don't qualify under RSA 91A as a public meeting, meaning that they don't need to take minutes, they don't need to post notice, and they don't need to hold their meetings open to the public. That is a misunderstanding of RSA 91A because it says clearly in the statute that any committee, subcommittee, or advisory committee is still considered a public body under RSA 91A. So that means that any entity that's created by a larger group, the select board creates a subcommittee, the planning board creates a subcommittee, those small advisory committees are still public bodies under RSA 91A, meaning that they, in order for them to meet and discuss official business, they need to properly post notice 24 hours in advance of their meetings. They need to take minutes, and they need to hold their meetings in a place open to the public. The one distinction that's been made by the Supreme Court here in New Hampshire is when a group of individuals, even potentially publicly affiliated individuals like public employees, choose to create a committee or a body on their own outside of the directive of the government, of the town. That group of individuals may not be considered a public body. And so the example we have from a recent court case is a group of public employees in the city of Rochester chose to make their own committee. They were not directed to do this by a department head. They were not told to do this by the select board. It was a group of concerned city employees that decided on their own that they were going to get together and discuss employment-related issues in the city of Rochester. And they brought their concerns to the city manager or the Board of Aldermen or whatever the governing body is in Rochester. And there was a question brought up of whether or not this group of employees was a public body under RSA 91A and therefore should have been holding their meetings in public and minutes and all of that. And the court said no, they were not a public body because they created this group on their own volition, that they were not directed to do so as a sort of an official board or body by the city commissioners. So that's the one real distinction that we have. In most instances, if you have a committee in town, it's going to be considered a public body under RSA 91A. So the next two elements, the final two elements of a public meeting are convening so that the members can communicate contemporaneously and discussing or acting upon official business. So what does it mean to convene? To convene means to meet in such a way that you can communicate back and forth. The obvious way of doing that is in a public place during a meeting, like a group of you are all doing right now, sitting next to each other. You can talk back and forth. You can discuss official business. That is convening as under the definition in the law. There are also other ways in which groups, public bodies can convene that maybe they don't recognize. And this can cause some conflict with the law. That's usually happens in a virtual space, via email or text message or on a conference call. When you have an email chain that includes all 3 members of the select board, and they're all hitting reply all and responding back and forth, that is an example of a public body convening, communicating back and forth. And if their discussion is about official business, well, they could be holding a de facto public meeting without having given proper notice or having the public available to read those email communications. So whenever you are engaging in electronic communication or communication outside of a properly noticed public meeting, you want to make sure that you are avoiding substantive discussions about official business. The official business prong, that final element, is sort of what tips the scales. This is the reason why the select board can hold a holiday party at one of their houses, and all three select board members are together in the same room talking with each other. There's nothing wrong with that as long as they're not discussing official business. And so anytime you have a majority of a public body talking back and forth outside of a public meeting, it's always important to make sure that you are not discussing official business, or else you could potentially be in violation of RSA 91A. The law specifically says that meetings of public body members that are less than a quorum to discuss public business should not be undertaken outside of a properly noticed meeting. And this is covered in RSA 91A:2-A, which talks about communications outside meetings. And the most important piece of that RSA is paragraph 2, which says communications outside a meeting, including but not limited to sequential communications among members of a public body, shall not be used to circumvent the spirit and purpose of this chapter. And so this section has been defined and interpreted to mean that the spirit of RSA 91A, the purpose that this law exists for in the state of New Hampshire, is to allow the public the utmost transparency in the actions of its government. The reason why we have the right to know law, and the reason why we give the public access to public records, the reason why we give the public the ability to attend meetings of public bodies, is so that our members of the public can have a seat at the table when their government, their elected and appointed officials are making decisions. And so when you communicate outside of a public meeting about official business, and those communications influence your decisions later on during a public meeting or a public hearing, that violates the spirit of RSA 91A, because the public was not present in that email chain. The public was not present during that text message conversation. So you want to make sure that you keep that provision of RSA 91A in mind anytime you find yourself communicating with another member of a public board or body, or of your public board or body outside of a properly noticed public meeting. So what are some ways in which members of a public body may be talking or communicating or even gathering together that is not considered a meeting, meaning it doesn't trigger the requirement that the public be present, it doesn't require notice, it doesn't require minutes to be taken? When might that occur? So there are a few exceptions within the statutes that are defined as non-meetings, that they are not meetings under the law. Those would be things like social encounters, like we talked about, the Christmas party. That's not a meeting as long as you're not discussing official business. Discussions about negotiating collective bargaining agreements. This is a specific carve-out in the law because the legislature has recognized that if you were to discuss your collective bargaining negotiating strategy in public, that may, seriously hinder your ability at the negotiating table. So discussions about CBA agreements are not meetings and can be done outside of the public's eye. Consulting with your town attorney. When you are receiving legal advice directly from your attorney, that is not a meeting. You do not need to open that to the public or post notice. Circulation of draft documents. Sometimes the board will be amending their rules of procedure or drafting up a new ordinance or something like that. And you have your draft that is completed, and needs to be voted on to be finalized. Sending that draft document out for the other members to review and prepare for their vote to adopt it as the final version, that's not a meeting. That doesn't count as a meeting as long as there is not substantive back and forth discussion about the content of the document. If there's discussion about the content, that needs to be done during a public meeting. And it's also just important to note and to understand that a non-meeting is different than a non-public session. Non-public sessions happen within a public meeting. non-meetings are by definition not a public meeting. So are there any questions on what I've gone over so far before we keep going?
Keep going.
Okay. What are the requirements of a public meeting? So now that we know the 4 elements that need to be present in order for you to properly hold a public meeting, you need to know that there are specific rules that must be followed when you hold that public meeting. Those are notice, open to the public, and minutes. And so when we talk about notice, there are a few different scenarios to be aware of. So the bare minimum notice, the basement of notice that will always apply no matter what as the minimum required notice of a public meeting is in RSA 91A, and it's 24 hours notice posted in 2 public places. If the statute does not require any more enhanced notice than that, then that's all you need to do. 24 hours, 2 public places, one of which can be your website if your town has a website. There are, however, many instances littered throughout the statutes where enhanced notice is required. For example, in order for the ZBA to hold a public hearing on a variance request, they need to send out notice directly to abutters by certified mail. They also have to post notice. I think it's 10 days in advance of the public hearing. For something like your budget hearing for adoption of a budget during town meeting season, notice for the budget hearing has to be posted 10 clear calendar days before the public hearing. So there are many events that will require enhanced notice to be provided in order for you to be able to hold your meeting or your hearing. And so the only way really you can know what the notice is that you need to post is to look at the statute. If you know, at the next meeting of the select board, we're going to be voting to adopt a particular ordinance or something like that, you need to check the statute to see if you have enhanced notice requirements. But if there are no enhanced requirements included in the statute, then all you need to do is post notice 24 hours in advance in 2 public places. Several years ago now, there was an emergency order in place during the COVID-19 pandemic, which allowed public boards and bodies to hold virtual meetings, meaning all the members of the public board or body could appear virtually. That is no longer the case. That was suspended, and now we are back to our regular 91A rules, which always requires that a majority of the members of a board or body be present in person, which means that to hold a meeting, you have to have a physical location that's open to the public, and in that physical location, you have to have a majority of your board or body members present. If you don't have a quorum present physically in person, you cannot hold that meeting. If you do have a quorum present, you've got your 5, you've got your 2 out of 3 select board members, you've got your 5 out of 7 planning board members present, you may choose to allow additional members to appear virtually. Notice that the statute 91A2 says may, it doesn't say shall. So what that means is that you can choose whether or not you want to allow somebody to attend a meeting virtually, a member of the board or body. So it is up for you to decide whether or not you want to allow remote attendance by board members who are unavailable to attend in person. In order for them to be eligible to attend a meeting virtually, the statute says that it must be not reasonably practical for them to be there in person. Now, it doesn't provide a further definition of what not reasonably practical means, so that is sort of up for your own individualized interpretation. And you can even establish this in your rules of procedure. You can decide for yourselves what you will recognize as being not reasonably practical. So that could be something as simple as, I am not feeling well tonight, so I want to stay home and not, spread germs. That maybe that's not reasonably practical, so you can allow them to attend in person. Maybe it's that they are traveling for work. They're in another state for work. They still want to attend the meeting. You could decide if that's not reasonably practical. maybe they're on personal vacation. That could be a situation that you find to be not reasonably practical, or maybe you choose to say that it doesn't qualify, that if you're on vacation for, pleasure purposes, that you have to miss the meeting. So you can decide these things for yourselves. Just know that it's an option. You don't have to allow remote participation. And if you choose to, you have to identify for the public who is appearing virtually. You have to include in your minutes why it was not reasonably practical for them to appear in person. And all votes done need to be done by a roll call vote. There is another provision within the law which allows for remote participation in an emergency. These are very rare circumstances, but in the event that there is some type of weather emergency and the main bridge in town has been taken out by a flash flood and a member of the select board can't get to the public meeting location and the board needs to vote on an emergency expenditure to reinforce the remaining bridge in town, or whatever emergency scenario, it would have to be fairly extreme. But if an emergency situation arises where you must hold a meeting and it is not possible to have a quorum present in time, you can still hold that meeting. But there are a few rules that have to be followed. First, the chair must declare that an emergency exists. You still need to designate a physical location for the meeting to be held at. However, a quorum will not be necessary to be present in person. You need to make sure that everybody appearing remotely can hear and be heard. And you still have to identify all those appearing virtually, and all votes need to be done by roll call. In order to avoid some of the common pitfalls of violating RSA 91A, we do have a few tips that we give municipalities, mostly to avoid violating the electronic communications rules surrounding RSA 91A. So some of the things that you can do to try to avoid unintentionally violating RSA 91A is to use an administrative person to send emails. If you have an admin official who's able to send emails out, they can act as sort of the middleman so that you don't have all three members of the select board communicating directly with each other via email. You have the administrative assistant being the one who initiates the communication and then is responded to directly. And the way that your administrative person can further insulate themselves from potentially violating RSA 91A is to use the BCC function on email. So if anyone is unfamiliar with this, email communications have two options for including additional recipients. You can put them in the CC line, in which they'll be provided directly a copy, or the BCC function. And the way that BCC works is that you cannot see the other people who are copied on a particular email. So if I hit reply all and the other members of my select board were included on the BCC line, my response won't go to all three members of the select board. It'll just go back to the original sender, which in this scenario is ideally an administrative official. So by using an admin person and keeping your additional recipients to the BCC line of the email, you can avoid that situation where you have a quorum of the select board or whatever public body hitting reply all and communicating back and forth. Using an official town email address is another good tool to avoid issues with RSA 91A. When we get to the section on municipal records and producing records, you'll see that email communication can sometimes be considered a governmental record. And many municipalities receive right-to-know requests on a regular basis for email communications between local officials. If you're using your personal email address to communicate about your official business, then those emails that you've sent, and consequently your personal email address, could be subject to public disclosure. And the contents could also be potentially subject to disclosure under a right-to-know request. So the easiest way that you can protect yourself from this is to use a dedicated email address. either your town has one, like I see that you have a croydon-nh.com email address. So in that instance, you could use that email for communication. But if you don't have one individually for your official work purposes, you can always create one yourself on a free website. You can go to Gmail, create your own Gmail address that's dedicated just for planning board purposes. And if you do that, then you'll at least have this, firewall, so to speak, between your personal communications and your official ones. And finally, the easiest way to avoid any violations of RSA 91A is to keep your discussion and deliberation of official business for a public meeting. It's okay to communicate electronically about administrative tasks like setting an agenda, scheduling meeting dates, rescheduling meetings if somebody is unavailable. But the substantive discussions about the topics of running the town, planning board business, conservation commission business, all of those type of discussions need to happen in a properly noticed public meeting to be safe and avoid violations of the statute. Now, we talked about the spirit of RSA 91A. The reason why it exists is so that the public has transparency in the actions of its government. And so inherent in the public's right to attend and be present at public meetings come with some other legal rights that members of the public have. They have a right to record, and they can record audio and they can record video, and they do not need to get permission to do so. It is presumed by law that during a public meeting or a public hearing, the public has a right to record, and you cannot restrict their right to record in a way that would violate their First Amendment privilege to do so. What you can do is put reasonable rules in place. If you're going to record and you have a big camera, you have a whole camera and boom mic and audio setup, you can ask that person to record from a specific area in the room to avoid blocking other people's views or interrupting, the board and their ability to conduct business. You can do things like that, but you can't restrict someone's actual ability to record. In addition, you cannot engage in secret ballot voting. Part of that public's right to know what their government is up to comes with their ability to know who is voting for what. And so members of the select board, members of other boards and bodies within town cannot engage in secret ballot voting. It has to be done by roll call or other open voting method. And finally, we have the issue of public comment. And so this is something that is can cause public boards and bodies somewhat of a headache when it comes to allowing public comment. And it's important to understand that public comment is not a right that the public has at any and all public meetings. In fact, the public is only allowed to, it only has the right, excuse me, only has the right to comment at a public hearing. At a regular meeting, they only have the right to comment if you choose to give it to them. And so there's a few observations and considerations that you might want to have when you are choosing whether or not to give the public a right of comment or not. First and foremost, you should have rules governing public comment before it occurs. You need to explain these rules clearly to everybody at the meeting so that they know what the rules of the game are ahead of time. When you do allow the public to speak, you're triggering the First Amendment, which means that you as the government cannot restrict their speech based on content. You cannot restrict opinions. You cannot restrict the content of what somebody is saying just because you don't like it or you find it offensive or inflammatory. What you can do is limit the time, place, and manner of speech. So what this means is that you can have reasonable rules like a time limit for how long you will take public comment. You can have a per person time limit. Each person gets 3 minutes to speak before their turn is over. You can implement rules where in order for somebody to be able to speak, they have to sign up ahead of time. And you can require them to send an email or to sign up on a sheet of paper or something at the meeting hall. You can say that we're only going to allow 10 people to sign up every meeting, and it's first come, first serve. The first 10 people to show up and sign the sheet are the ones that are going to be allowed to speak. Those are rules that don't restrict the content of speech, but they restrict the time, the place, and the manner of speech. Rules that you cannot impose are positive comments only, no use of vulgarity, no use of offensive speech or offensive language. Those types of rules are based on the content of the speech, and the Supreme Court has ruled over and over again that those type of restrictions violate the First Amendment. So you want to make sure that when you are implementing rules, you are doing so in a way that respects people's First Amendment rights. You should also note that if somebody is violating the rules that you've imposed, you cannot remove them after one strike. Realistically, it has to be a minimum of three strikes and you're out rule. As we've seen in some of these cases, the courts have recognized that a minimum of 3 warnings is going to be necessary before you consider having somebody be removed for failure to abide by your public comment rules. You should remind them if somebody's speaking out of turn, if somebody is going too long or being disruptive, you should remind them that we have these rules in place. This is what the rule is. This is what you're doing to violate those rules, and let them know that if you continue to do so, you may be subject to removal from this proceeding. But you want to make sure that you give at least a minimum of 3 warnings. Minutes are required to be taken at all public meetings and public hearings. The law requires certain things to be contained in those minutes. It says that you have to include the names of the members, the persons appearing before the public body, a brief description of the subject matter discussed, state any final decisions that are made at the meeting, and the names of the members who made or seconded each motion needs to be recorded in the minutes. Meeting minutes, at least draft meeting minutes, are supposed to be available within 5 business days of your meeting. So if somebody comes and makes a request to view meeting minutes, they don't have to be approved minutes, but you do have to provide them with draft meeting minutes 5 business days after the public meeting. If you don't have your draft minutes done, that's okay, but you have to give them something. So if your draft minutes aren't complete and somebody makes a request 6 days after the meeting, you might have to provide them with your notes or whatever it is that you're going to use to ultimately create those meeting minutes. If your board votes to approve the meeting minutes, let's say at the next public meeting, the law requires you to post approved minutes to your website. If your municipality uses a website, you have to post approved minutes to the website. And you can use software to record meetings, but it is really not recommended to use recordings as a substitute for meeting minutes. Meeting minutes have to be kept forever. Under RSA 33-A:3, the law requires meeting minutes to be kept forever. And so recordings can be bulky and big and take up a lot of space to save. And which is why, to comply with the law, all you need is a brief summary, written summary of what was discussed to constitute your meeting minutes. And that's going to be a lot easier to keep long-term than big files that are audio or video recordings. So I mentioned a few slides ago that non-public sessions are different than non-meetings. They are still meetings, and they happen within the confines of a public meeting. And so what that means is that in order to enter non-public session, you have to first be in a public meeting. It's a carve out of the larger public meeting. It is also the exception, not the rule. And what that means is that you are never required by law to go into non-public session. The law does not say you must go into non-public session. It says you may go into non-public session. So what that means is that it's discretionary, that each board or body can choose whether or not they want to go into non-public session, assuming that the reason to go is a qualifying reason under the statute. And in order to go into non-public session, you have to first identify the statutory reason for doing so. And so we see that in RSA 91A:3, where the statute lists several reasons why a public board or body may choose to enter non-public session. Some of those reasons are to discuss the hiring or firing or compensation of a specific public employee, discussing something that may harm a specific individual's reputation within the community, the sale or purchase of real or personal property, discussion about lawsuits pertaining to the municipality, discussions on preparing for emergency situations, discussing legal advice, or discussing student tuition contracts. If the discussion falls into any of those categories, you may choose to enter non-public session. In order to do so, first, somebody has to make a motion to enter non-public session. So that can be as simple as a member of the public board or public body, or a member of the public who's allowed to speak may stand up and say, I move that the board enter non-public session. In that motion, it must, under the law, it must state the reason to enter non-public session. And so you need to include in the meeting minutes the reason under 91A:3 that the board is justifying entering non-public session. Once you enter non-public session, all votes must be done by a roll call vote, and you still have to take meeting minutes. The need to take minutes doesn't end just because you entered non-public session. Those minutes still need to be recorded. Some of the more common reasons why boards enter non-public session are to dismiss the promotion, compensation, discipline, or investigation of charges concerning a specific public employee. This must be a particular employee, not a group of employees. So if you want to discuss giving the entire highway department a 3% cost of living raise, you can't do that in non-public session. If you want to discuss giving just the highway director a $10,000 bonus, that can be done in non-public session. The law says that an employee may have the right, usually within their employment contract, to demand that the discussions take place in public session. If they have that right, you want to make sure that you inform them before discussing the particular issue in non-public session and allow them the opportunity to demand a public session before engaging in such a discussion in non-public. Matters which, if discussed in public, would likely affect adversely the reputation of any person other than a member of the public body itself. This is the most commonly used reason that boards enter non-public session. I also think it's the most commonly abused one. The point of this exemption is supposed to be to avoid causing someone direct and calculable harm to their reputation. Not just, I don't want to say something negative about this person in public. There really needs to be some additional reason why this particular discussion about this person might cause some enhanced level of harm to their reputation. So I'd recommend using this exception sparingly. Most common, it's used correctly when dealing with financial issues. If somebody's coming before the select board to plead for an abatement because they can't pay their property taxes because of a whole boatload of personal reasons that would be humiliating to have to lay out in public, that'd be a good reason to enter non-public session under 91A:3(2)(c). But if I want to get up before the select board and complain that I don't like the fence my neighbor posted, but I don't want my neighbor to know that I'm complaining about my neighbor's fence, that may not be a good reason to enter non-public session. There's no real reputational harm that's going to occur from that type of discussion. So I would recommend using it sparingly. I mentioned that minutes of a non-public session are taken just like minutes of a public session. You still record all the actions that are taken and all the votes. The only difference is that non-public minutes can be sealed. Once the non-public session has ended, the board can vote to seal non-public minutes if they wish to do so. In conducting a non-public session, You may make decisions. There's no rule. Sometimes people think that you can't vote in a non-public session. That's not true. You can make decisions. You can vote. Um, if a member of a public board or body feels that the board entered into non-public session inappropriately, meaning they shouldn't have done so, you can object for the record under 91A2, and that person's objection will be included in the minutes, and then they can continue their discussions. It's sort of a safeguard to say that you feel the board is violating the statute, but you still want to be allowed to participate. And then after public session has ended, after non-public session has ended, you're supposed to return back into public session before either continuing with your business or closing out the rest of the meeting. There are some other considerations you might want to take related to non-public sessions. If you know that you're going to enter non-public session, maybe choose to include that on your agenda if your board uses agendas that are posted ahead of a meeting. Be cognizant of the timing. Maybe choose to hold your non-public session right at the beginning or right at the end of a meeting so that you're not wasting the public's time for those members who are not going to participate in the public session, non-public session. And then finally, consider who you allow to attend. There's a reason why it's supposed to be a non-public session, there's a reason why you choose for it to be a non-public session. There's no purpose in going into non-public if you're going to allow 7 or 8 people to be present when you only need 2. So really restrict attendance in your non-public sessions to only those people whose attendance are absolutely required. Once the non-public session is over, you have 72 hours to determine whether or not you want to seal those minutes. In order to seal the minutes, you need a 2/3 majority vote. And that vote must be taken in public session. And so the reasons why you might choose to seal non-public meeting minutes are because if you disclose those minutes, it would have an adverse effect on somebody's reputation, because disclosing them would make ineffective the whole reason for entering non-public session in the first place, or because the discussion in non-public session pertained to terrorism or other serious public safety concerns. So those are the reasons listed in the statute why you might want to seal your non-public meeting minutes. As of January 1st, 2022, all municipalities are required to keep a list of their non-public sessions. This list needs to include what public body entered non-public session, the date and time, the reason under 91A3, the exemption that you used to enter non-public session, the date that you chose to seal the minutes if they were chosen to be sealed, and the date of any subsequent decision to unseal those minutes. So this is a running list that's supposed to be updated regularly, and this list is subject to disclosure under a 91A request if somebody from the public wants to see this list. You also have a requirement to periodically review your sealed minutes of non-public sessions to see if they are eligible to be unsealed. And so what that means is that if there is no practical reason for these minutes to remain sealed, then you can unseal them, and you should unseal them. And that can be done just by a simple vote during any public meeting of your board or body. But there is an expectation that you go through over the next 10 years, now we're down to 8 years, over the next 8 years, that you review all of your past sealed minutes to see if they are eligible to be unsealed. And that was a change in the law in 2023 under HB 321. There are some additional tips that we provide to sort of help boards have more effective public meetings. Obviously, being as prepared as possible is going to help you in the long run, making sure that you know what's on the agenda and that you've reviewed your materials ahead of time. Having rules of procedure that govern not just public comment, but procedures of the board members themselves, how you're going to address, motions and duties of the chair and things like that are all great tools that you have at your disposal. Using an agenda to keep meetings on track is a great option. Circulating materials in advance, and obviously avoid having discussions prior to or outside of a public meeting. When we talk about rules of procedure, every single public board, body, and committee is allowed to adopt their own rules of procedure. These are your guidelines. They're your bylaws that help create a well-organized and a well-running public body. You can create rules of procedure about almost anything, but some of the ones that you might want to consider are establishing regular meeting dates and times. If you're a board like the planning board that has to meet once a month, keeping it regular and structured helps with notice, helps with consistency. Many select boards meet, the same date and time every month or every couple weeks or whatever it might be. Annual election of officers. We get these questions a lot in the legal services department. When do we elect our chair? When do we elect our vice chair? How long do they serve as chair or as vice chair or whatever? And they want to know what statute outlines this. And the answer is there isn't one. Most statutes, most public boards and bodies don't have a statute that says you elect a chair every 2 years and the chair serves for a 3-year term of office. And if your chair is, if the board becomes dissatisfied with their chair, here's how to remove them from that position. That doesn't exist in the RSAs. That's up to you to establish in your rules of procedure when you're going to elect officers and terms of office and all of that. Even the authority of the chair. You can't designate a chair of any one public board or body, a super weighted vote or something like that, but you can give them specific authority that you want. So giving the chair the ability to set the agenda, for example, is what a lot of boards or bodies do. Duties and privileges of other board members, quorums and voting rules, agendas for board meetings. You can also include rules about order of business, how business will be held, meeting procedure and decorum. Are you going to use motions and seconds and things like that? Public comment rules we talked a lot about are very important. Rules regarding the right to know law, committees, liaisons, and appointments, and enactment of ordinances, resolutions, and motions. All of these issues can be addressed in your rules of procedure. So with that, I'll pause again for questions if anyone has any questions before we move on to the public records portion of RSA 91A.
The records, they're just sealed. How far back do you have to go? I mean, when did the town first start keeping records? 1700 something?
Yeah.
Do they have to go back that far?
Yeah, unfortunately, the answer is yes. The legislature chose to say that municipalities need to go back for as long as you have records kept and review your sealed non-public meeting minutes over the next 10 years. The consequence is that if you don't, those records automatically become unsealed at some date in 2033. How that's going to be enforced, nobody knows. So our advice is just to do your best, to put in a good faith effort to try to review these minutes periodically over the next 8 years now.
Thank you.
Anything else? Okay. So we'll move on now to governmental records. This is the portion of 91A that seems to cause the most headache for municipalities. Right to know record requests have increased for sure over the last 3 or 4 years. They've increased not only in volume, but in size and consistency, and even in maliciousness, as we've seen in some instances where, unfortunately, some towns and cities have dealt with predatory record requesters, people who seem to make it their life goal to hamstring municipalities with large and unnecessary record requests. So it's important to understand what your limited rights are to protect yourselves as a municipality from these type of requests, and to also abide by the law and allow citizens the access to the records that they are legally allowed access to. So RSA 91A:4, paragraph 1 has a few key terms in it. It says that any citizen is allowed access to public records. The problem is the law did not define the term citizen. And so we are left sort of holding the bag, not knowing if that means a citizen of the state of New Hampshire or a citizen of the United States, meaning that anyone from out of state is allowed to ask for records to be produced under New Hampshire's right to know law. It also doesn't give us a definition of whether or not corporations are considered citizen, as our Supreme Court once held a few years ago now. So dealing with this can create some really complicated scenarios, especially when you get requests from out of state. Many municipalities have been getting requests from businesses, from educational institutes, from individual people sending electronic requests via email or some other electronic means, asking for huge amounts of records to be sent to out of state, to be uploaded to some website, to be emailed to them. And we get a lot of questions and concerns from municipalities saying, how are we supposed to deal with this? How can we produce 50 years worth of records that need to be reviewed and redacted and then emailed to this private university out in Utah? That's going to take us hundreds of hours and it costs us, however many thousands of dollars, and we don't have any ability to recoup those costs in time or money. So, what can we do about that? And so the real answer to that question lies in the first paragraph of 91A:4. And what it says is, minutes and record, every citizen during the regular or business hours of all public bodies or agencies and on the regular business premises of such bodies or agencies has the right to inspect governmental records. And so the key there, the section that is in bold, is that the law requires that you to make public records available on the regular business premises of your public bodies or agencies. It does not say that you need to send records via email, that you need to upload records to somebody's website, that you need to print out records and put them in the mail for somebody. None of those are legally required under RSA 91A. What is legally required is to make those records available during the regular business hours at your regular business premises. And so maybe the best and really only tool that municipalities have to protect themselves from some of the more voluminous or even predatory record requests is to consider implementing a policy which requires people to view records in person at the town clerk's office or at the police department or wherever the records are kept on the regular business premises. Implementing a policy that in order for you to receive copies, either virtually, by email, printed out, whatever, however anybody wants to get their copies, in order for you to get copies of records, you first have to view them in person on the regular business premises. Implementing this rule, which you are legally allowed to do so under the statute, is a great tool so that when you get that request from some, private corporation out in another state asking for you to produce thousands of pages of records, you can say to them, we'd be happy to produce whatever records are available pursuant to your request. How about you make an appointment to come down to the Croydon Town Hall during regular business hours to view those records? And then once you've looked at them, if you want a copy, we'll provide you a copy, however you want it. Most of the time, municipalities never hear back from that person again, because they're not going to fly down to New Hampshire to go look at those records. And so you won't have to fulfill that request in the way that they're specifically asking for it. And that can save you hundreds of, maybe thousands of dollars and hours in work. So that is your single biggest protection under the right to know law when it comes to record requests. Requiring an in-person appointment also gives you the option to do we've sort of been calling batch responding. And so what I mean by this is that sometimes municipalities will get a request for a whole bunch of records, and it's even from somebody in town. Like, let's say it's from a local person, a New Hampshire citizen, maybe somebody from Massachusetts, close by, and they are actually willing to come to the town clerk's office to view the records at an in-person appointment. Um, if something like that happens and this person makes a request for thousands of pages of public records, what you can do is tell this person, listen, it's going to take us, maybe months to find all of these records. Why don't you make an appointment for 30 days from now? We'll schedule you for a 2-hour appointment at the town clerk's office to review these records, and we'll produce the first 20 pages that we can find. We'll find the first 20 pages relative to your records request. We'll review them, we'll redact them, and we'll get them ready for you to view. And you make an appointment and show up and view those records. And if you do that and you view those first 20 records at the first appointment, then you can make another appointment for 30 days later, and we'll get you, another 20 or 40 or 60 records, whatever you can handle. Doing it like that does a few things. One, it requires the person making the request to have some skin in the game, so to speak. They have to show up. They have to show up to their appointment. That's an affirmative act on their part to show that they're actually making this request in good faith, instead of just requesting it and then never showing up just for the purposes of wasting your time. The second thing it does is it limits your exposure on how much time you might waste. Because if they never show up for their first appointment, you've only spent, let's say, 3 hours gathering 20 records and reviewing them versus 300 hours gathering 3,000 pages, reviewing them, redacting them, and then having that person never show up for their appointment, or emailing it, even worse, spending all that time not requiring an in-person appointment, emailing those records to that person, and then they never even opened that email because the only reason why they made this request was just to chew up time, which unfortunately is something that we have seen happen. So having an in-person appointment requirement gives you that flexibility to make multiple appointments to respond to bigger requests in smaller pieces that are more manageable and waste less time and resources. If you do receive a request that appears to be exceptionally large and difficult to understand, there's some leeway in the law for you to try to work with this person to get this request to be reasonably described. If you don't even know where to start to look for these records because it's such a broad or vague request, you can follow up with the person making that request and ask them to narrow down what it is that they're looking for, to reasonably describe it. Sometimes we get these requests where somebody says, I want every email sent between the select board and their department heads over the last 20 years. And municipalities are like, well, what am I supposed to do with that? That could be thousands and thousands of emails. I don't think we've even kept most of those, but how do I tell? A follow-up phone call asking for this person to clarify and say, listen, I understand, you're making this request for all of these records. Is there a specific topic perhaps that you're interested in? Or is there a specific issue that you are really trying to get information about? Can we narrow this request down in order to make it, more of a feasible records request? You can ask for them to provide a more reasonable description so that what it is that you're looking for. Once you've identified the records that you're looking for, you need to show that you've engaged in a good faith search for those records. So what that means is that a municipal employee who's familiar with your record keeping protocols and practices can show that they looked in all of the areas where those records may exist in order to find records related to that person's request. And the reason why it's important to show that you had a reasonable search for these records is because the crucial issue is not necessarily whether documents related to the request exist and were missed, but whether the search was reasonably calculated to discover those documents. So if you happen to miss a page here or there, or there's an individual record that maybe should have been produced but was kept in the wrong filing cabinet, in some other office. It's okay if you miss that record. You're not going to be fined. You're not going to be sued or found in violation of the statute for missing that record if you show that you engaged in a good faith, reasonable search for the documents that were requested. There's three key steps that you want to undertake when you receive a request for records under RSA 91A. The first is to determine whether or not it actually is a governmental record. Only governmental records are subject to disclosure under the right to know law, and not every record is a governmental record. So identifying whether or not it even is a governmental record as a first step is going to determine whether or not that document is even subject to being disclosed. Once you've gathered your governmental records, you want to find out whether or not the information contained within those records is exempt. There are a number of exemptions in the statute that we will go over, and reasons for why a record might be exempt from disclosure. And then finally, you need to make those non-exempt records available within a certain statutory and reasonable time period. So to start, what is a governmental record? It's any information created, accepted, or obtained by or on behalf of a public body or quorum or majority thereof, or any public agency in furtherance of its official function. So what that means is that information, tangible information, records, recordings, pictures, whatever it might be, that is accepted, produced, or obtained by a public body in furtherance of its official function is going to be defined as a public record. And what is a public body? It's the same thing that we talked about when we defined public body for the purposes of a meeting. Select board, planning board, ZBA, advisory committees. The government record also includes agencies. So an agency would be your police department, your health department, your highway department. Those are agencies. The records of those agencies are also considered governmental records. And governmental records can come in a number of different forms. They can be paper documents, they can be emails, voicemails, text messages, digital recordings, photos or videos, or information saved on the cloud or on the internet. All of those types of documents or records can fall into the category of governmental record. Sometimes it's easier to understand this concept by talking about something that might not be a governmental record. So I'll give you two examples that I've had of requests for information that were not governmental records. So the first was from a select board member. This is a 3-person select board. They were holding a public meeting, and at one point during the public meeting, one select board member leaned over to the other and made a comment, like whispered something in his ear. I think they both laughed or chuckled or something, and then the meeting continued, and nobody could hear what was said. But a member of the public noticed this exchange, and they filed a right to know request saying, I want to know what was said between those two select board members. That was a quorum of the select board, 2 out of 3. I want them to write down on a piece of paper what it was that they said between themselves. And the answer to that is there's no governmental record there. A governmental record has to be something tangible that can be produced. And you can't force a person or the government to produce a record that doesn't exist. And so there was no recording of this meeting. There was no written transcript. The minute taker didn't hear what was said. So there was no record to produce. So there was nothing to respond, no substantive response that they could give to that person. There was no governmental record. The other example that I have is from another member of a select board who received a text message during a public meeting or a public hearing. And he looked down at his phone, or he took his phone out and looked at it. And the text message was from his wife. And it said she was having surgery or something. And it said, just got out of the appointment. Everything's fine. And some member of the public saw the select board member look at his phone and filed a right to know request wanting a copy of the text message that he looked at. And he asked me, is this something I have to give over? This text from my wife that I happened to read because I was nervous, during this public hearing. And the answer is no, for two reasons. One, it was not a communication between um, a public body, because it was just one member. It was just one member of the select board, not a quorum. So him alone doesn't constitute a public body. So his individual text message would not meet the definition of a governmental record. More importantly, is that it wasn't in furtherance of his official function. So even if, let's just say, because crazier things have happened, two members of a three-person select board were related, and they both got the same text message from, from the guy's wife, who was also the aunt of the other select board member or something. And they both got the same text message that said, just got out of surgery, everything's fine. Now you actually have a quorum of a public body receiving information, but it's not in furtherance of their official function. This person's health status is not related to their official business. So even though that text message was received by a quorum of the public body, it is not a governmental record, and it wouldn't fall under that definition. So if it is not a governmental record, it's not subject to a right to know request, but in most cases, outside of some of these more random ones that we've had examples of, records kept by the select board, by the public agencies, are going to be governmental records. And so when you've gathered your governmental records pursuant to a right to know request, your next step is to figure out whether or not information contained within those records is exempt from disclosure, because not everything is subject to public disclosure. There are a few documents that the law 91A specifically says are public record. If somebody makes a request for these records, you're not going to have a reason not to provide it. These records must be provided. Those are employee separation payments if they were made in addition to regular salary or accrued vacation or sick time. The meeting minutes or raw materials that are used to create meeting minutes if the minutes themselves have not been made yet. And any lawsuit settlements that are on file with the town clerk must be made available for inspection for a 10-year period. Those type of records are listed in 91A4. They're not going to be exempt for any reason. You're going to have to provide them. For the most part, exemptions are going to be a little bit harder to decipher. 91A5 provides a list of some records that are categorically exempt, meaning they are just not included in public record disclosure. Those are things like master jury lists or teacher certification record. But for the most part, determining whether or not information is going to be exempt from disclosure is going to require somewhat of a detailed analysis, because the right to know law is designed, again, as we've mentioned a few times, to provide the utmost of information to the public about what their government is up to. The point of 91A is transparency in government. If disclosing information does not serve the purpose of showing the public what the government is up to, disclosure may not be required. But if a public body is seeking to avoid disclosure of material, you have a heavy burden to explain why that information is exempt from disclosure. And the most common exemption that we have is what has been called the privacy exemption. And it's included in this paragraph in 91A:5. About halfway through the paragraph, as you can see in bold, it says, all other files whose disclosure would constitute an invasion of privacy. Those files, those records, that information is exempt from public disclosure. And the reason for that is because violating somebody's privacy does nothing to further the public's knowledge in the government. The reason why 91A exists is so the public can see what its government is up to, not so that the public can see what their neighbors are up to. And so when private information is contained on a governmental record, that information may be subject to a redaction so that it is not available when that record is disclosed. Private information can be anything from somebody's name, address, email address, phone number, information about their employment, information about their home, their property, their salary, obviously some, the more sensitive information like medical information, any type of personal identifying or otherwise personal information that regular citizens have to provide to their government in order to do the things they want to do, in order to, build their house, build a deck, register their vehicle, because they were arrested or investigated by the police department. All of these reasons why government agencies interact with private citizens and inherently obtain information about them. All of that is information that could be considered private. But the question is whether or not it's private enough for you to have to redact it. And this is where things get a little bit complicated. So, bear with me and we'll try to do the best we can to explain this. So whenever private information appears on a governmental record, the Supreme Court of New Hampshire has decided through a series of different cases that everyday local officials, people who have been appointed or volunteered for their position, have to engage in this somewhat complicated legal balancing test to decide whether or not they should redact information. We call it the private versus public balancing test. And so the way that it works is, first, you have to identify whether or not there is a private privacy interest. And as I mentioned, almost any time personal information about a private citizen appears in a record, you can reasonably conclude that there's some level of privacy. It might not be a big privacy interest, but it's at least some level of privacy interest. When you have private information about a private citizen on a governmental record, then your next question is to ask what public purpose would be served by disclosing this information. So to put it another way, how would violating this person's privacy advance someone else's knowledge about the government? Not about the private person, but about the government. And then finally, you have to balance those two interests and figure out whether or not the scale tips towards disclosure or tips towards redaction. And that can be a daunting task. It can be confusing to figure out and hard to understand. And so the best way, I think, to try to explain this is to use some real life examples to show you how this test has been applied in certain situations. So here's the first example. This is a question that we've actually gotten a lot. I don't know if Croydon has received this, but many towns have been receiving public record requests from commercial entities, enterprises for very specific property information, houses which have filed, piece of property which have filed building permits and solar exemption applications. I think there's a contingency of businesses in the area that have identified that using public records, they might be able to gather information about private citizens to help them market products or services towards these people. And so this was an older example that we got, and maybe you'll see how this privacy exemption sort of played out. In this example, somebody made a right to know request for all the building applications that were filed in the town in the last month. And what he wanted specifically was the name of the person who filed the building permit, what their address was, and information about the project that they were seeking approval, a permit for. And the town reached out to us and said, we don't know about this. Should we give this person, this individual, all of this private information about our residents? And so the answer that we gave, in our opinion, in this instance, was the person's name and address is considered private information. And in order for us to violate their privacy and disclose that information through public records, what public purpose would there be in releasing this information? And there was none. We could not come up with a public purpose based on the content of the request as to why giving all that information out was relevant to what the government was up to. The part that was relevant about what the government was up to was the project. It's the government's role to approve or deny building permits based on for the project. So we said you can redact the name and address and provide the rest of the permit, showing the description of the project and whether or not the building permit was processed or approved on time. That's government function, processing building permits on time and fairly and accurately based on the project and the permitting requirements. The name and address doesn't give the public anything else, any further information about what their government is up to. So that's what we did, and it turned out to be important because they later found out that the person making this request owned a lumber yard in town, and what they wanted to do was they wanted to target advertise their lumber yard to everybody who was engaging in a building project that maybe was going to purchase lumber, which is obviously not the point of RSA 91A. It's not to spend taxpayer dollars and resources to disclose private information about its residents so that this lumber yard can make more money. So that was a good example of using that private versus public balancing test and coming out on the side of privacy and redacting. But how could we change the facts so that the public interest might outweigh the private interest? And so for that, I created this hypothetical scenario with, let's say that the same request was made for building permits with names and addresses associated. And the town responded by saying that the name and address would be redacted under the privacy interests. What if the person responded by saying that they were dissatisfied with this approach because the reason for their request is that they were concerned that the municipality was treating certain portions of town unfairly. Maybe there were certain households in town that they were multifamily, and it seemed like they were all getting their building permits for new ADUs denied, while other residents were getting them approved. And under the current state of the zoning ordinance or the law, both multifamily and single family should have been getting them all approved. And this person thinks that the town, the government, is applying the building permit process unfairly. And so in order to know that, in order to have transparency about their government, they would need to know the address. This would be a situation in this hypothetical where perhaps the public's interest in knowing that the government is treating, various different addresses fairly would outweigh a person's privacy interest. And so here you may want to redact the person's name, but keep the address available. So that's one example of how this private versus public balancing test could play out. Here's another one. This is another real example. This town published their assessing records on their website so that anybody with an internet connection could look at them. This is not a legal requirement. Assessing records are supposed to be made available at the regular place of business. There's nothing wrong with posting them online, but you don't have to do that. And a police officer in town called and asked for his assessing information to be taken off the website because he felt that this was a safety concern for him and his family. So here, the officer had a legitimate privacy interest in his information being made so easily and publicly available. And the town is going somewhat above and beyond the record requirements by posting the information online. So here we felt that it might be appropriate for the town to decide to take his information off the website and just keep it available at the assessing office or the town clerk's office. And so the officer followed up and said, thanks for taking my information off the website, but I'd actually like you to redact my name entirely from the public assessing record, the official record. Here, there is still a privacy interest, but assessing records do serve a public purpose. The town is required to keep record of who owns property to properly assess taxes. And the public has an interest in knowing that the town is fairly assessing property taxes. Furthermore, this information is available elsewhere, like the Registry of Deeds. And if this person wanted their name and address more adequately protected, they had other options like putting their property in an LLC or something like that. And the town has already sort of made some level of accommodation to protect this information. So the public would have a compelling interest in being able to have access to an accurate assessing card, which would outweigh this person's privacy interest. So in that instance, we recommended keeping the record intact. So those are two, real life examples of how we applied this complicated private versus public balancing test. So hopefully that helps, maybe explain the how to apply it a little bit better. There are some other easier exemptions to be aware of. Preliminary drafts of documents are not public record, so you don't have to disclose your rough draft if you don't want to. And personal notes, if you take personal notes on the margins of documents or something like that, your own personal notes are not subject to a public record request. Law enforcement records are another one. They're their own sort of specific category of records. They apply 91A still applies to the 91A standards. The private versus public balancing test still applies to police records, but police records also have additional exemptions from FOIA, which is the Freedom of Information Act. That's sort of the federal right to know law, and those standards apply in conjunction with right to know for police records. And so the additional exemptions to be aware of are if disclosure of police records would interfere with law enforcement proceedings, interfere with a fair trial, constitute an invasion of privacy, reveal confidential sources, disclose investigative techniques or procedures, or endanger someone's life or safety, those records are also exempt from disclosure under those provisions. So I have another real life example. This is probably the most common one that we get, where a police department received a right to know request for all records involving a particular person and a particular address. So we see these all the time. Police departments receiving a public records request saying, I want all police reports or police records related to John Smith and 123 Main Street. And in most cases, the reason for this request is because that person is involved in some type of divorce proceeding or complicated custody case, or perhaps it's an attorney that's representing this person in some criminal matter, and they're trying to gather all information they can about witnesses or they're trying to dig up dirt on the other party to use against them in court or something like that. And they think that they can get this information with one simple right to know request. But the answer is they really can't, or they shouldn't at least. There's no public interest in providing police reports or police records about police interaction with a private citizen to some other private citizen. The only purpose that it serves is to violate somebody's privacy and to arguably violate a pretty high level of privacy. The courts have recognized that citizens have a heightened privacy expectation with their interactions with police departments because of the stigma or because of the sensitive nature of what could be happening. So police records are subject to an extremely high level of privacy. And there's no public purpose in a request like this that would warrant violating someone's privacy and producing those police records. So in most cases, these requests are totally exempt from disclosure under RSA 91A. There are limited ways in which somebody may gain access to these records. Under 91A, a public records request, really the only way that they should be able to get access to these records is if there's a health and safety concern. And that is solidified within the statute. So in this instance, let's say that the person making the request for these police records is the parent of a child. And the reason why they're making this request is because their child was present at this address and in the custody of, their dad or whatever, when the police responded. And the mother wants to know, was my child safe? There's a specific exemption from that included in 91A5, which would allow you to release records relative to somebody's health and safety to someone who is responsible for their health and safety while still redacting the private information about the other people involved. So you could, in specific instances, overcome a privacy exemption in that case. But for the most part, police records are going to be exempt from disclosure under the privacy exemption. Releasing information that could allow someone to circumvent your IT security, that is also exempt from disclosure. So any information that would result in a potential security breach of your internet security protocols is exempt from disclosure. And communications with your attorney. So the attorney-client privilege still exists for municipal records. Those are exempt from public disclosure. So now we get to our last step in record production, which is making non-exempt records available. So once you have gathered your governmental records, you have reviewed them for exemptions and redactions, you need to make those records available for public inspection. There are some rules to follow when producing access to public records. The law says that records must be provided immediately only when they are immediately available for release. So what this means is that citizens don't have the right to just show up and demand access to records on a whim. The courts have recognized that local officials don't need to be subject to having their entire day hijacked by somebody who walks in off the street and demands access to governmental records. Many records require time to gather, to review, to redact. It is totally appropriate to tell this person that you've accepted their record request, but it's going to take you some time to fulfill that request. Only if those records are immediately on hand, meaning there's something like meeting minutes that really are never going to be subject to redactions and should be available in an easily accessible location. Something like that is immediately available. You can make it available to somebody who comes in off the street. But if it requires some time to review records or find them, you are more than within your rights to ask for them to come back at a later date or to make an appointment. You are never allowed to charge fees, a flat fee to produce records or to produce copies of records. The only fee that you are allowed to ask for is a reasonable per page copying fee if you need to produce photocopies. If somebody requests photocopies of records that they want to take home, you can charge them a reasonable, per page fee for the cost of ink and paper and something like that. But you can't charge them arbitrarily a flat fee just to have access to documents. That's not allowed under the law right now. And when it comes to electronic records, you can't charge somebody a fee to give them copies of electronic records. What you can do is you can ask them to pay for the cost of a flash drive if you want to put your electronic records on a flash drive. If you're going to email them records, they want copies of emails to be forwarded to them, presumably after they've reviewed those records at an in-person appointment. You can only charge them a fee if the records are over 250 communications. That was a recent change in the law, and it requires a pretty big request. But if there is over 250 email communications and they want you to review those and send them, you can charge a $1 fee per communication over 250. But other than that, you can't charge a fee to provide electronic records because it doesn't cost you anything to send them. Now, the law says that you have 5 days to produce records pursuant to a right to know request. And so is that necessarily true? Well, the law says that you have to provide something within 5 days, but that something doesn't necessarily have to be those records. It just has to be a response. And so you have to respond to a record request within 5 business days, but you do not have to produce all of the records if it's going to take more time to search for those records and to redact them and to do all of the things necessary to produce them. You should provide a written statement acknowledging that you've received the records request. You should provide a reason for the delay if it's going to take you some time to get those records prepared and ready. And some of the reasons why you might ask for additional time are you need time to determine whether the records actually exist. You have to search for them. You need time to determine if the information contained in those records is even subject to disclosure or if it's subject to an exemption. And if those records are disclosable, then you maybe need to make those records ready for reviewing and copying. All of those reasons are valid reasons for asking for additional time under the statute. There are specific record retention requirements that you have under the statute, and there are also remedies that the public has for violations of Chapter 91A. And so when it comes to record retention, the most important statute is going to be RSA 33-A:3-A. This statute contains 156 categories of records that need to be retained for some period of time. Records must be retained for the statutorily required period. And once that period has expired, those records can be deleted or discarded. And so you want to make sure that you're keeping records as long as they're supposed to be kept and that you're routinely deleting records, because keeping records for longer than you need is really only creating more work for you and setting you up for a potential violation of RSA 91A. If you have really old records that you chose to keep and didn't realize that they still existed, you might miss those when producing records, a record request, and that could potentially cause an issue. So your municipal records committee should be reviewing records periodically to make sure that they're ready to be deleted. And a note on deleting records. When you delete records, especially if they are electronic records, you want to make sure that they have been deleted from all the possible locations where they could have been stored. What that means is that if your municipality is using some type of backup system where you are copying hard drives or email servers or you have cloud storage or something like that, if those backup mechanisms are making duplicates of governmental records, emails, communications, documents, whatever it might be, you need to make sure that when you're deleting those records, you're deleting that email inbox or you're clearing out that building permit file on your computer of old permits that don't need to be kept anymore. You want to make sure that you're also deleting them from anywhere else that they might be backed up, because if they exist in duplicate somewhere else and you miss that because you thought that they were deleted the first time, that could be viewed as a violation of RSA 91A. You are allowed to store all of your governmental records electronically. It is more spatially, it's less space consuming to store records electronically in PDF version than to have boxes and boxes of paper records. So if you want to start converting your paper records into PDF format or start creating all your records electronically, you are allowed to do that. You just need to make sure that you're following RSA 33-A:3-A and saving them in the correct format. Now, there are a number of ways in which violations of the right to know law can be managed and handled. In the past, the only option was through a court case. You could file a complaint in a superior court and have a judge adjudicate the alleged violation of RSA 91A. Now there's another option called the Right to Know Ombudsman. This is a one-man office that was created back in 2022. And the Ombudsman is an alternate option for litigating right to know disputes that is a bit easier and maybe faster than going through a full court case. Anyone who is aggrieved under the law by a failure to disclose records or by an alleged violation of RSA 91A may choose to bring a complaint either with a court or with the Ombudsman. So the ombudsman's office is a simplified process. It doesn't require as much time and as many hearings as going through a whole court case. Yet the ombudsman is empowered to do most things that a superior court judge can do. He can order timely delivery of public records. He can conduct review of records, compel interviews. He can order attendance at hearings. And he can issue penalties if he finds that one side or the other did violate the right to know law. He can order penalties to be paid. We've seen many cases handled by the ombudsman's office since its creation, and it does seem to be a good process that it's streamlined some of these right to know complaints. There are a number of different remedies that could be awarded based on a violation of RSA 91A. Yeah, is there a question?
Can you let Melissa back into the room? She had a power discussion.
Oh, okay. Yep. Okay, so there are a number of remedies that could be awarded for a violation of the right to know law. The court or the ombudsman can issue attorney's fees for either side, whether it be the municipality or the citizen. They could be awarded attorney's fees. If a public board or body violates RSA 91A, the meeting requirements, they don't post notice, they don't take proper minutes or something. The court could invalidate a vote or action that was taken at an improperly held meeting. There could be civil penalties awarded if there's a bad faith violation, meaning somebody intentionally violated the statute. The court could issue an injunction. An injunction is when the court forces somebody to stop doing something. Many times the remedy is ordering training. Municipalities that have been found to have violated the right to know law have been ordered to take additional training on the right to know law. Obviously, if somebody knowingly destroys records to avoid having to produce them, that's a serious offense. That could be a misdemeanor, which is a crime. As I said, attorney's fees could be awarded even to the town if somebody files a frivolous lawsuit or an unjust lawsuit against a municipality. So those are some of the remedies available for violations of the right to know law. So with that concludes our overview of RSA 91A. I'm happy to take any questions that might arise before we close off the recording. And then when we're done, we'll have the recording downloaded and we'll send it out to you.
Are we still, do we have to compile a special records request? I'll go back to your building permits.
Yep.
Ask for building permits. Do we have to give them all the single family building permits, or is it just the whole entire file?
That's a great question. So the courts have ruled that municipalities are not required to compile records pursuant to a record request. So what that means is that in your example, let's say somebody says, I want all the building permits issued for single family homes in the last 20 years. You could provide them access to all the building permits in the last 20 years, especially if that's how they're stored. You have a box full of building permits, you can hand it over to them at an appointment and say, you go through and find what you want. You are absolutely in your right to do that. You don't have to compile records for this person that are not already compiled in the format that they want it in. The catch here is that sometimes it's actually easier to compile records for somebody, especially when it has to do with sensitive information. So in the building permit example, let's say that you felt you came to the conclusion that somebody's name and address on a building permit is private and shouldn't be disclosed. And I say it that way because This is not a hard and fast rule. This is the building permit example I gave was just one interpretation of I think a reasonable way you could interpret the privacy exemption, but not the only way. And so let's just say that you came to the same conclusion that it's private enough information that any member of the public shouldn't have access to everyone's name and address associated with their building permit. In that instance, you wouldn't be able to give them the box of all 20 years worth of building permits and say, go through it and find what you want, because you would have needed to pick out the specific ones to redact the information, and they would have access to all the other people's building permits. So in that instance, maybe pulling the specific ones they're looking for is going to save you time, as opposed to having to redact all of them or something like that. I see this more often also with police records, where somebody might ask for they may ask for all the calls for service in a particular area. Like I want a record of all emergency responses on Christie Road in the last 5 days. Now, maybe some of that information is exempt from disclosure, but you could definitely argue that the number of dispatch calls on Christie Road in the last 5 days, just the number is probably public record. But police departments don't have a document that just separates out Christie Road. They have all the dispatch reports for that day, but they have the ability to create, type in their computer system Christie Road and have a printout that just has that week's calls on that particular road. They don't have to do that for this person. They could give this person a 50-page long document of all the dispatch calls that month or that week, with all the addresses or all the names redacted and just the roads listed. And this person could go through and count themselves. Okay, there were 10 on Christie Road. They could do that. That's probably more work than just using their, software to pull out the Christie Road dispatches, redact the name and the house number, and then give that, to the person. So it's a cost benefit analysis when it comes down to it, whether or not you want to maybe do a little bit more upfront to make it easier on the back end. Anything else? All right. Well, thank you for having me present today. We love doing these on demands. I think it's great to help sort of focus in on some of these more complicated legal topics. So thanks for your participation. I hope you enjoyed this presentation. And so with that, I will stop the recording.